before this judge even calls the first name, the tension is already baked in. Because Kevin Dean Ross isn't just walking on one case. He's walking in with a stack of problems. A brand new felony evading charge, plus 2 separate motions to revoke probation from earlier cases involving a deadly weapon in a penal institution and another vehicle pursuit. That means this isn't just about what he did last month. It's about whether he's proven over time that he can follow the rules at all. The court immediately references a prior high-speed chase with DPS, a video the judge remembers well enough to have already rejected a lighter deal once. That's a huge signal. When a judge says, "I remember the video," it means the facts weren't minor, the risk to the public wasn't small, and the court is not starting from a place of sympathy. And now Ross is back, again, facing another evading with a vehicle charge while already on deferred probation for similar conduct. That pattern matters. Then comes a legal fork in the road. The state offers a plea with an 8-year cap, not a guaranteed sentence, just a ceiling. The judge explains in plain language what that really means. Plead guilty now, waive your jury trial, and put your fate in her hands, with the possibility of anything from probation-level mercy all the way up to 8 years in prison. Or reject it and take your chances with jury and potentially far more time. And here's where it gets even heavier. This one decision doesn't just affect the new case. It threatens to collapse his old probation cases too. Because when you violate deferred adjudication, the court can pull back that second chance and impose full prison sentences on the original felonies. So this is no longer just about one night, one chase, one mistake. It's about a record, a pattern, and whether the court still believes rehabilitation is possible or whether public safety and accountability now outweigh every other consideration. So as this unfolds, ask yourself, if you were standing there facing an 8-year cap but risking far more things go wrong, would you take the deal or would you gamble everything on a jury?
For some reason. I'm sorry. Good morning. Are you Kevin Damon Ross?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor, there's two, I believe, 2 MTRPs and...
One new case. Okay, so he'll waive the reading of the motion as well.
We're going to enter pleas of true count 1, which is the new case allegation, and then there's an agreement on all 3.
All right, let me let's go forward with the new case first.
And
Then.
we're asking for an updated PSI.
Thank you, please.
And Judge, if you need, more than that, all of the other counts stem from the sole incident. I think the court has reviewed the video previously of the evading. You'll recall we had an agreement of 5 a while back, and the court rejected that, understandably, just because we're doing an update. If you need more.
I don't remember the video. You have to tell me more, but
It was a very high speed evade through multiple areas of the county with the DPS.
okay. While on probation for evading. Yeah, I remember now. And what was the agreement that I had rejected before? Okay. All right, sir. In cause number 25, DCCR 1310, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 13th of 2025. And how do you plead to that charge?
June.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here, in that case, some documents on the tablet that have your signature on them. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And if I follow this agreement, I cannot give you more than 8 years. I can give you 8 years, I can give you less. It'll all depend on the information that's presented to me when we come back for sentencing. You have an absolute right to have a jury come in and do two things. The first is to determine if you're guilty or not. And then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right. And is that what you want to do? Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. Ross is not competent? All right, sir. In that case, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and we'll come back later for sentencing.
This is one of the most legally important moments in the entire hearing. Even though it sounds calm on the surface, the judge is very carefully making a record that Kevin Ross understands exactly what he is giving up. An 8-year cap means the court cannot sentence him above 8 years, but can absolutely sentence him to 8 years or anywhere below it, based on the pre-sentence investigation, his history, the fact of the chase, and now, even his behavior in custody. She also explains the constitutional rights being waived, the right to a jury to decide guilt, and the right to have that same jury decide punishment. Once he says yes, that safety net is gone. No jury, no second guessing, just the judge, the file, and the facts. Then comes the immigration warning, a reminder that a guilty plea can carry consequences far beyond prison. Deportation, exclusion, denial of naturalization. Even for citizens, it shows how a single plea can ripple into every corner of a person's life. But the real weight hits when the court ties the new plea to the probation revocations. These older cases, deadly weapon in a penal institution, and evading in a vehicle, were deferred, meaning he once avoided a conviction and prison time. Now, with new arrests, drug allegations, rule violations, and financial delinquencies, that grace is on the brink of being withdrawn. The judge finds several violations true and makes it clear sentencing is coming, and everything, past, present, and in custody behavior, will be on the table. So here's the question for the audience. When someone keeps repeating the same dangerous conduct, at what point does the system stop offering chances and start imposing the full weight of the law?
Obviously, anything that you think is important for me to know, you'll get that information to Mr. Burbank, and he'll present it to me on that day as well. So then we have cause numbers 24 DCCR 1198 and 24 DCCR 1199. Each of these cases, I have motion to revoke unadjudicated probations. It looks like in 1198, you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a third-degree felony, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 24, DCCR 1199, I also have that motion to revoke your unadjudicated probation. Shows you were placed on probation that same day in December of 2024 for the third-degree felony offense of evading arrest or detention with the use of a motor vehicle. Is that also correct?
Yes, ma'am.
So if it's unagreed, somewhat unagreed, I want to go ahead and go through the rest of those allegations. I think I need to know if the punishment's up to me, what the pleas are, what all's been going on, not just the one new case. So I'm going to go through them all. If you need a minute to go over that with him, otherwise I'll just go through. So, Mr. Ross, both of these motions allege in count 1 that you were arrested for the offense of evading arrest or detention with the use of a vehicle on June 13th of 2025. That's the case you just pled guilty to. And is that true or not true?
Yes, ma'am. Sure.
And that's one of those, Ms. Malfino, that probably needs to be looked at. Being arrested for it isn't really it's true, it's fine, but that language, y'all need to get them to change that language.
Okay.
You know what I mean?
I do.
Count 2 alleges that you were arrested for evading arrest or detention. That was that same day. Is that true or not true? So that's not in the vehicle. That means that you got out of the vehicle and then ran. Is that true or not true?
Sure.
Count 3 in each case alleges that you were arrested for possession of marijuana June 13th of 2025, that same day. Is that true or not true? Okay. Count 4 in each case alleges that you possessed marijuana in violation of your probation order on that same day. Is that true or not true? Okay. Count 5 alleges that you tested positive for cocaine on a drug patch June 13th of 2025, and is that true or not true?
Not true.
Count 6 alleges that you were at a location other than your residence at approximately 1:39 a.m. on June 13th of 2025. That's true?
Yes, ma'am.
And then count 7 in each case alleges that you're a little behind in your court-assessed fees in each case. Is that true or not true? Did you enter your pleas of true in each of your cases to counts 1, 2, 6, and 7 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
All right, then I'm going to find in each of your cases that, in these cases also, I have here on the tablet some documents that have your signature on them. Did you also go over these with Mr. Burbank?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And again, you understand if I follow any agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal.
Yes, ma'am.
And are these just no agreements just to run concurrently?
Well, no, there's a cap of 8 on those.
Y'all didn't write that on here.
I thought I did.
All right, or it might not have come through. So so cap of 8 in each.
Yeah,
So the agreement is the same as the other case,
Yes.
that I can sentence you up to 8 years in prison or less, depending on the information that's brought to me in a hearing. You understand?
Yes, ma'am.
State tenders number 1 in each of those
no
cases.
objection, states one in each case.
It's admitted in those cases. Mr. Ross, I'm going to find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probations. However, I'm not going to do that today. I'm going to reset your cases for sentencing. We'll get the probation department to do updated reports, and then, again, anything that's important for me to know, get that information to Mr. Burbank, and he'll present it to me on your behalf when we come back. And if there's anything of those that you feel like proving up at that time, I think it's just mainly the drug patch and that possession of marijuana, but
Okay,
either
I'll
way.
have the probation officer here, Judge, but would you like to hear from that trooper? He's been relocated.
No, I think we're good with the others. So, Mr. Ross, I also, before you go back with the bailiff, I have in my hand jail incident reports.
Yes, ma'am.
So if you're going to come in here and ask me to do something other than 8 years in prison and give you some kind of circumstances good, it's not going to happen. The names you are calling these correctional officers, the rules that you're breaking, the gambling with the I mean, it's not allowed. If you can't follow the rules in jail, then what makes you think that I'm going to do anything nice for you? If you call people,
With the last one,
y'all talk to Mr. Burbank about it, okay? But the name calling, you know what I'm talking about, right? Okay. I don't care what they're doing their job, right? So they're going to work every day, they're going home, which is hopefully at some point what you would like to do in your life. Get a job, go home, be with your family. And if you had someone like you acting like that at your job, when you're just trying to do your job and enforce the rules, you're in jail. You got to follow the rules. You don't want to follow those rules? Then stop committing felonies.
yes, ma'am.
All right. Go back with the bailiff. We'll see you at sentencing.
Have excuses.
Yes.
This final exchange pulls the curtain back on how much more the court considers beyond the original charges. By the time Kevin Ross is sent back to the holding area, the judge isn't just looking at a high-speed chase or probation violations. She's looking at his conduct inside the jail itself. Name-calling, rule-breaking, gambling, and a complete lack of respect for correctional staff. And her message is unmistakable. If you can't follow the most basic rules while already incarcerated, how can a court trust you with freedom, leniency, or anything less than a serious prison sentence? Legally, the path is now set. Ross has pled guilty to evading arrest with a vehicle, accepted an 8-year sentencing cap, waived his right to a jury, and admitted to multiple probation violations. The judge has ordered updated pre-sentence and probation reports, meaning every detail of his past, his behavior, and the risk he poses will factor into the final decision. At sentencing, she can impose anything up to 8 years on the new case and fully revoke his deferred probations, converting what were 1-second chances into real prison terms. The broader implication is clear. Deferred probation is not forgiveness. It's conditional trust. Break that trust, and the system responds swiftly, firmly, and with very little patience left. If you found this case as intense and eye-opening as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns where real decisions carry real consequences.
Sir.